Buenas tardes a todos. Les quería compartir esta historia que escribí para el diario El País sobre el litigio o los litigios de los cubanos con I-220A. Hablé para esta historia con el abogado Mark Prada, que lidera varias demandas en diferentes tribunales sobre este asunto. Quería compartirle algunos puntos claves de la historia. Por ejemplo, el abogado Prada me confirmó que el fallo principal que ellos, o sea, el litigio principal que ellos están tratando de convertir en una demanda colectiva, que es lo que se conoce como un class action en Estados Unidos, es una demanda en el Tribunal Federal de Miami. Ellos tienen dos casos ahora mismo en Miami. Uno de ellos es para cubanos, es enfocado en los cubanos con I-220A, y ellos pidieron al juez que lo convirtiera en un class action, o sea, hicieron esa solicitud. Esto es un proceso que me explicó que toma una cantidad de tiempo. Al final el juez es el que decide, o sea, no es una cosa que se dé por hecho que se va a convertir en una demanda colectiva, pero en ese caso él hizo la solicitud, él y su equipo hicieron esa solicitud. Ahora, hay otros casos en los cuales han tenido audiencias recientemente en otras cortes, y quería aclarar esto, que me pareció importante porque yo le pregunté y él me aclaró. Hay los dos casos que hay en las cortes de apelaciones del segundo circuito de Nueva York y el onceno circuito en Atlanta, Georgia. No son demandas colectivas, son apelaciones. O sea, eh, el proceso funciona así: uno va ante un juez de inmigración, si rechaza la solicitud, se apela en la Board of Immigration Appeals. Si la Board of Immigration Appeals rechaza esto, que es la famosa vía, se puede ir a la Corte de Apelaciones, que es donde ellos están ahora. Pero esos casos, eh, técnicamente, no pueden convertirse en acciones colectivas, son casos individuales. Es la ley técnica, la forma que se manejan esos casos, que sí pueden establecer un precedente, es cierto, para personas que viven en los estados que abarcan estos circuitos, ¿no? Si es en el de Nueva York, en los estados que abarcan el de Nueva York, si es en el de Atlanta. Ahora, lo más preocupante que me pareció a mí es que incluso si ellos logran que el juez les dé la certificación de class action para la demanda de Miami y logran que la corte falle a favor de ellos, ¿no?, en la demanda, el gobierno puede apelar ese fallo. Y no solo esto, sino que es muy probable que el gobierno apele este fallo. Pues estamos hablando de cientos de miles de personas. O sea, la población de cubanos con I-220A se calcula entre 400.000 y 500.000 personas, ¿no? Entonces, vamos a pensar, el gobierno está eliminando las protecciones temporales, o sea, los permisos legales para estar en Estados Unidos de países completos. O sea, ya casi no queda nadie con TPS, ¿no? Los venezolanos, que eran un estimado como de 600.000 personas, les quitaron el TPS. Los haitianos, se estima una población similar a la de cubanos con I-220A, eso es casi medio millón de personas que no tienen, que se van a quedar sin autorización. Entonces, ante esa situación, o sea, ante esta actitud del gobierno, por decirlo de cierta forma, es de esperar que apelen a esta demanda, ¿no? Pero si los tribunales aceptan este argumento y la corte falla a favor, esto podría abrir un camino hacia la residencia, porque establece precedente de que el I-220A, este documento, equivale al parol.
The case in the 11th Circuit and the Second Circuit are appeals from deportation orders
Okay.
from the Board of Immigration Appeals. So there's no way to join multiple cases in those proceedings. Those are individual by design. So you go to immigration court. If you lose, you appeal to the BIA, the Board of Immigration Appeals, and if you lose there, you can do petition for review in the circuit court that applies to where your case happened. So those are two separate cases. One was a case out of Miami. That's the 11th Circuit case, and then another one is a case from New York that's in the Second Circuit. Aside from that, there's lawsuits in district courts, but those are completely different issues, or different cases altogether. So the issue is that we're arguing that people with I-220As or other documents because it's not just I-220As, were legally released on parole because there's no other explanation for how they're at liberty. Okay, so that is that case. We're doing it in different ways, though, right? So in the past, if people had their residence denied, we would sue on the denial, like basically appealing the denials to the district court. Now, the government has many ways to make those cases go away. So we never get a decision, but the case would be resolved for those clients specifically, but not everyone else. Right? So those are things that have been happening.
What does it mean that they were released on parole because there is no other explanation? What do you mean by that?
Well, legally, there's different statutes that govern detention in different circumstances. So depending on the statute that applies to your case, either you're not eligible for release or you are. And in those cases where you're not eligible for release, the deportation officer can still let you go with parole, right? So, you know, an example of eligible for release is you ask a judge, an immigration judge, to give you a bond. But that doesn't apply at the border. So our theory is that at the border, you're not eligible for release. You're supposed to be detained unless a deportation officer, right? So the factual circumstances with these people is that they showed up at the border and presented themselves to immigration to claim asylum, and they were released. And the way the law works is there's no way that could have happened except for parole. But then the government is just giving them different documents so they don't have the benefit of a parole, which would allow them to apply for Cuban Adjustment Act or anything else.
Right. And if any of these appeals succeed, or any of these lawsuits and district courts that you mentioned, will they apply, the ruling will apply to a broader population of Cubans with I-220 to adjust their status under the Cuban Adjustment Act?
The appeals in the circuit courts, if they are issued as precedential decisions, right, and that's up to the courts, would apply in various states. So the 11th Circuit governs Florida, Alabama, and Georgia. The Second Circuit is New York and Connecticut and Vermont, if I recall correctly. So those decisions would be confined to those areas of the country. With the lawsuits in the district court, we're trying to get class certification for the entire country. So right now we're just kind of waiting on decisions.
And that will be the entire population of Cubans with I-220A?
I mean, that's what we're asking for. So it's basically up to the judge if she'll grant us that or not. We're just waiting on decisions right now. I mean, we briefed a lot of stuff, and we're waiting for the judge to make a decision.
Right.
And if we win and they're treated as being paroled or ordered to be given parole documents, then that would open the door for them. I mean, that's the point of doing it in the federal court, because we're trying to obtain relief in a way that would help everybody as much as possible. I mean, I'm sure there's a different set of hypotheticals for every person, and their case is all different. But we're just trying to get the most expansive form of relief to help as many people as possible.
Right.
So, you know, it would apply whether they're in immigration court or not, depending where they are, and kind of just depending on what the judge does. Because, you know, just because we present it as a class action in a certain way doesn't mean that's what the judge is going to do. Maybe she will redefine the class and make it more narrow.
Right.
And, you know, so that I have no control over. We just kind of have to wait and see what happens, right? It's just, there's a lot going on.
Right. And what about people who are detained or they're facing detention or removal right now? People who are maybe in Alligator, Alcatraz, or one of these detention centers, will they still benefit from a ruling in these cases?
I mean, as long as they're still here by that time. Like, unfortunately, you know, the current government is going full force and trying to do things as fast as possible. And you know, we're in a position right now on all of the cases I've been talking about of waiting for an order.
Right. Right.
So that's basically up to the courts to, you know, they're taking their time. They're figuring out what they agree on and not, and they're going to write a long decision explaining everything. And you know, it's not something where they just snap their finger and that's the answer. You get me? Like, they have to take their time to do a proper decision.
Right. Right. And then can the government appeal to that decision?
Yes.
Mm. And do you think they will?
Just given the amount of impact of what we're doing, I would assume that they would want to. That
Yeah.
they're not. I mean, I don't know. Maybe they choose not to. It
Mhm.
kind of just depends on what, you know, Donald Trump considers to be a priority, and specifically Stephen Miller, right? Like, he's the one who's kind of puppeteering the president right now. And like, Cubans are being targeted very heavily, but they're not like the main thing, I think, for the government or the administration. I mean, honestly, I would assume they would be very upset if we were to win. But I don't know what they would do afterwards. It's just speculation at this point.
Gracias a todos por escuchar. Ahí les comparto el link de la historia. Hasta la próxima.